Yesterday was a big day for the federal courts, but you were too busy Googling things your 12-year-old neighbor called you to find out whether melt maxing is a good thing or not. Don't worry, I got you. Happy Wednesday, everybody. I'm Brian, and this is the morning report for the federal courts for August 13th, 2025. Do me a favor, drop a comment or a like, and if all possible, watch the whole video. It helps get this thing out there so people will see it. And I'll tell you right now, I'm saving Newsom v. Trump for last. I would stick around. All right, you ready? Let's go. We are going to start with LULAC real quick. That's the League of United Latin American Citizens. Now, I've reported a couple of times about DOJ filing a bunch of motions to extend deadlines because they're kind of getting in over their heads. The thing is that in some of those, they're admitting, hey, we're in over our heads. I'm supposed to be in 3 states on the same day. In others, they're using real arguments, like trying to blame it on the plaintiffs. So the plaintiffs filed an opposition to the motion to extend, but they didn't mention that the same DOJ lawyer has been filing these extensions all over the country because I don't think they noticed. So if anybody knows their lawyers, tell them to follow me, I guess. All right, let's check out National Endowment for Democracy v. US. The NED is an agency set up and funded by the National Endowment for Democracy Act, so it has its own law. The NED Act says that the State Department has to pay X amount of money annually to the NED because that money isn't the State Department's money, it's the NED's money. And the State Department is not allowed to require the NED to comply with any special requirements to get its money. Cut to 2025, when the State Department stopped paying NED and said some sort of special waiver was required for them to get access to their funds. And then the State Department submitted a full year spending plan to Congress saying no more money would be given to NED, and any money left over in their accounts that hadn't been dispersed yet would be subject to review for alignment with Trump administration priorities. Well, yesterday, the judge in the case issued a preliminary injunction enjoining the State Department from withholding, blocking, reserving, or otherwise interfering with the payment of appropriated funds for fiscal year 2025 to the NED. Also, the State Department is required to file a status report by August 13th, which is today, confirming that they're complying with the order. So we will see what the status report says. My guess is it'll say they haven't had time. All right, let's take a look at New York v. Trump. Now, this is a Doge case where a coalition of state attorneys general have sued the administration over Doge's access to Department of Treasury information, so tax records. And the plaintiffs are asking the court to grant a temporary restraining order and preliminary and permanent injunctions to prevent non-Treasury employees from having access to Treasury Department payment systems or data systems. Basically to limit all of our tax data to people who work at the Treasury Department. And the district court granted a preliminary injunction way back in February, and they've modified it a couple of times. And then the federal government filed a motion to dissolve the preliminary injunction in May, and that was denied. Now, most of the argument in this case revolves around standing, whether the plaintiffs actually have an injury that they're claiming, or what they call a redressable injury, which is something that the court can actually fix, redress. And if there's nothing for the court to fix, then there's no case. And that's kind of what the government is arguing. And that's part of why this case is brought by attorneys general here. It would be hard for anyone else to make a solid argument that they have a specific redressable injury. AGs are sort of in a special position where they represent the interests of kind of the people at large in their state in sort of a very special way. So anyway, now the federal government is moving on to the Court of Appeals for the Second Circuit. Now, technically this all went down a little while ago, but I wasn't doing a morning report back then. Yesterday, there were some filings about the district docket and record being sent over to the U.S. Court of Appeals. Seemed like a good time as any to catch you up on this. All right, last but definitely not least, I spent 5 hours yesterday listening to the trial testimony from the Newsom v. Trump trial from Monday. There's actually a ton of interesting stuff in there. I am just going to try to hit a few of the high points, though. The big issue is that the military cannot be used to enforce domestic laws. Domestic meaning American. But they can protect the police or ICE or whomever while they enforce domestic laws. But the line between, say, performing an arrest and protecting the person performing the arrest is very messy. So there were a few lines of questioning in the trial that I want to point out. First, there were questions about kind of what actually happened on different days and at different times, trying to nail down the facts. what did the military actually do? Did they protect law enforcement or did they enforce the laws? So that's one. Two, when should the military be deployed to protect federal law enforcement? And the answer mostly came from a witness named Major General Sherman, and seemed to sort of shock the judge a little, or at least grab his interest. Because we have a law that says there are times when the military is not appropriate, but the Major General had trouble nailing down a situation where he didn't think the military should be sent in. Like if there was an assessment of zero danger, or if the agents were enforcing a tax law. And the Major General just kept saying, nope, send in the military, totally appropriate. So, okay. And then the third questions were about the standards that the military follows to make sure they don't hurt Americans. Because hanging kind of over this trial, and referenced several times, is the specter of the deployment in DC, and the chance that these deployments could become more and more frequent in the future. And the judge acknowledged that his decision in this case had wide-ranging implications for the safety of Americans. So, when does the military in a domestic situation on American soil go from standing there looking intimidating to fixing bayonets? And the answer seems to be that the guidance given to the troops is to stay on the sidelines until they perceive a threat. And the judge tried to nail down a definition of the word threat, and he did not find one. The answer seems to be that whomever is in charge in the field, which Major General himself said might be a 22-year-old who doesn't really know what he's doing, and I'm paraphrasing that, but those are kind of his words, gets to decide when there's a threat. And the judge seemed a little unhappy with that, or not maybe totally satisfied. It's just up to that person whether or not American civilians stay safe. Okay. Well, quick recap of those three questions. 1, what did the military do in California? 2, when should the military be sent in? What are the rules? And 3, once the military is there, when does the military engage with Americans? So that was my mile-high takeaway from the plaintiff's questions from day one. And I'm going to cut it off there because otherwise I will go on for an hour. I'll get to the second day's testimony tomorrow, and we'll see what the defendants have to say. And I believe Major General Sherman will be back as a witness for the defense as well, so it's likely he'll clarify these answers a little bit on the second day. All right, that is your Wednesday morning report for the past day in the federal courts. Again, if you can leave a comment or a like to get this out there, I'd appreciate it. Thank you for making it to the end. And if you know someone who'd like this, please share it. Otherwise, keep watching, everybody. I'll keep going. Thanks a lot. Have a fantastic Wednesday.